Good afternoon, all you.
Ah, hello. So if we're all ready, I think we might start. Welcome everyone to this second round of the competition. You may have seen some of the judges before, but we're, as it were, judging you afresh. You've each got, as you know, 45 minutes. How you allocate that time amongst your team members is up to you, but it's very helpful if you let the judges know at the outset of your submissions how you're intending to divide your time. But I will keep a rough track of your time and let you know if you're running up against it. Unless anyone has any questions at the start, I propose to invite senior counsel for the claimant to open the case.
All right. May it please the court, my name is Kawthar Belkacir, and I am senior counsel for the claimant, Ms. Artemis Astortia. And I'll be accompanied by Kabisha Shuling, acting as the junior counsel for the claimant. I'll be taking around 18 to 20 minutes for my speech, and we will use the 45 minutes with my junior counsel. Would Your Honor benefit from the facts of the present case?
A very brief summary.
The defendant in this case is Soul Dream Incorporated, a Canadian space flight company that has been operating for 3 years and provides space tourism services. The claimant, Ms. Artemis, is a successful yoga and travel YouTuber who entered into a spaceflight agreement with the defendant on the 10th December 2023. After purchasing the spaceflight tickets, the claimant underwent medical evaluations to ascertain her fitness to participate in the flight. However, she did not disclose her chronic headaches to the defendant on the 1st February, and she was placed under quarantine for 2 weeks alongside the other passengers in preparation for the flight when she began to suffer severe headaches. The claimant's headaches persisted until the 15th, the date of the launch. Prior to the launch, PCR and lateral flow tests were conducted to ensure that the crew and passengers were free from the COVID variants that had been spreading. The flight is launched only after receiving the lateral flow test results. The PCR results later revealed that the claimant carried COVID, and she was promptly quarantined. The remainder of the crew and passengers soon contracted the virus, and the flight had to return prematurely to Earth. The claimant sued the defendants under tort and contract by reason of inadequacy of safety protocols. The defendant's counterclaimed for the damages caused by her breach of contract. Your Honor, we submit that the key issue in this claim is whether Solar Dream Incorporated is liable to Ms. Artemis Astortia by way of committing a tort of negligence and by way of breaching their contract. Your Honor, I will present our case under 2 distinct submissions, the first being that Solar Dream has breached their duty by acting below the standard of care and caused the claimant loss. My second submission will be the contractual breach of the defendant. Your Honor, may I proceed with my first submission?
Yes, please do.
Thank you. My first submission regards the duty of care that the defendant owes my client. Firstly, Your Honor, the DIFC law of obligations mentions that a defendant would be liable in negligence if they had a duty of care, breached it, causing loss to the claimant. Therefore, Your Honor, let us consider the liability in tort and elucidate on the duty of care owed by Solar Dream to its passengers, including Artemis. Under Article 18, subsection 1 of the DIFC Law of Obligations, which can be found in the Claimant's Bundle, page 21, this duty is grounded in 3 fundamental components: foreseeability, proximity, fairness, justice, and reasonableness. Firstly, given the nature of the Vulcan virus and its known transmission risks, it was reasonably foreseeable that launching a spacecraft without definitive confirmation of all passengers' health status could result in infection and subsequent spread. The very essence of foreseeability lies in the anticipation of risk, a risk that was glaringly apparent yet ignored by Solar Dream. The relationship
Is that right? Was it glaringly apparent? I mean, they've got a number of potential passengers. none of them were showing any symptoms apart from your client who had headaches, but she didn't tell them. So as far as the defendant knew, it had people who didn't have any symptoms. They'd all taken lateral flow tests, which came back negative.
Yes, but Your Honor, the lateral flow test cannot be 100% it cannot be relied on 100%.
A
And
PCR test might not be 100% reliable. The obligation is to take reasonable care, isn't it? So why does the duty to take reasonable care extend to a PCR test?
Because a PCR test is at least more more reliable than a lateral flow test, which is a PCR test is considered in the lab and taken more, I guess, seriously than a lateral flow test. And yeah. May I continue, Your Honor?
Yes, please do.
Thank you. The relationship between Soul-Dream and Artemis is not merely contractual, but inherently proximal. As a service provider, Soul-Dream engaged directly with Artemis, thus establishing a clear and sufficient closeness that mandates a duty of care. That is not a distant or abstract relationship, Your Honor. It is direct and personal, intensifying the duty owed. Furthermore, it is not only just and fair, but also reasonable to expect that Soul-Dream, a commercial spaceflight operator, would uphold a high standard of care, particularly in maintaining robust health safety. And the nature of the commercial space travel, coupled with the known dangers of the Vulcan virus, unequivocally necessitates an elevated standard of care, which in this case Soul-Dream failed to meet. These three pillars underpin the undeniable duty of care that Soul-Dream owed to Artemis and all passengers aboard. Their failure in this regard is not merely an oversight, but a fundamental breach of the duty required by law and by the ethics of their industry. Your Honor, as per Article 21, subsection 1 and subsection 2 of the same law, available in the claimant's bundle page 21, reasonable care encompasses actions that a prudent operator would undertake under similar circumstances. Instead of ensuring all PCR test results were received, which is critical in ascertaining the health status of passengers amidst a global pandemic, Soul-Dream, gambling with the health and safety of their passengers, opted to rely on lateral flow tests. There is some evidence that lateral flow tests
They didn't just take that decision themselves, though, did they? Because they had advice from a nurse who said it's fine to rely on the lateral flow test. So does it make a difference that Solar-Dream relied on medical advice?
Yes, Your Honor, the nurse that they relied on was employed by Soul-Dream, and it is...
Well, I'll tell you this. Every lawyer who acts for a client is employed by the client, but the client is still relies on the advice of the lawyer because the lawyer is, fulfilling a specialism. What I'm wanting to know from you is why it is unreasonable for Solar-Dream to take a decision that involves questions of medical care by relying on the advice of a professional medic.
In this case, Your Honor, the advice that was given by the nurse was faulty, was mistaken, and therefore, as she is an employee of Soul-Dream, it is their fault, making it vicarious liability. And why not the advice? Why not rely on the advice of a doctor instead of a nurse who is more experienced in this field and more reliable?
Please do carry on with your submissions.
Thank you. Your Honor, there is some evidence that the lateral flow tests are the case, though the counsel for the defendant may argue that statistically they were not at fault for relying on a lateral flow test, it is surely expected of a spaceflight company to hold itself to a higher standard than mere statistics. Knowing that there is a risk of the test being misleading, Soul Dream should have taken more care to procure the more guaranteed PCR test results sooner. The fact that they did not is negligence, as it shows a lack of reasonable care. And in this instance, it led to Artemis unknowingly boarding the spacecraft while infected. Article 21, subsection 3 of the Law of Obligations, which you may find on page 21 of the court bundle, states that a professional person exercises reasonable care if he shows the standard of care of an ordinary skilled person exercising and professing to have the special skill in question. Furthermore, Article 21, subsection 4 of the Law of Obligations on the same page highlights that where there are different views within a profession about what constitutes reasonable care, a professional shows reasonable care when he takes an approach endorsed or followed by a responsible body of professional opinion. To substantiate this law, I would like to draw your Honor's attention to a highly significant common law case of the United Kingdom, Bolham and Fern Hospital Management Committee, decided in 1957 and reported in the second volume in the All England Law Reports, page 118. You may find this case on page 8 of the court bundle. Would Your Honor benefit from the facts of this case?
No, I'm familiar with Bolham.
Thank you.
Your Honor, could you please explain if this is binding for this court?
Your Honor, I'm using this case for to persuade Your Honor on this issue.
So it's not binding?
For persuasive purposes. Thank you. The court in this case established that a professional must act reasonably and in accordance with the practices in that field. Your Honor, I would like to highlight that in the present case, the standard expected of Soul Dream is clearly one of adherence to stringent safety protocols, especially since it is involved in such a high-risk industry.
Where are those safety protocols? You're relying on essentially the Bolham style analysis, which looks to a body of opinion within a profession. Where's the body of opinion as to lateral flow versus PCR?
The safety protocols are in the contract, and
where does the contract say anything about PCR tests or lateral flow? Just help me.
It says that on clause 4, and also clause 7 also mentions the safety.
I understand it's got to have, well, clause 7 requires them to make reasonable efforts to ensure that various protocols are complied with. There's nothing specific there, is there, about lateral flow or PCR?
There's nothing specific about the PCR or lateral flow test. However, they do mention the medical test that should be done, that should be carried out during the mission or before the mission.
Well, it seems to suggest it's up to the medic to determine what they need to test.
Yes, but as I've said before, the medic is also employed by Soul Dream, and Soul Dream is the company in this case, and is the one that makes the last decision, in my opinion. Thank you. As I've said before, this case or this mission involves a high-risk industry, which is space travel. However, the defendant failed to do so by relying on a lateral flow test, which has evidence of failure in some instances, and launching the flight with an unknowingly sick person, therefore causing the spread of the virus among all of the passengers. Counsel for the claimant submits that by departing from the expected level of care, which are the standard characteristic of skilled entities possessing special skills relevant to commercial spaceflight, Soul Dream has failed in its duty. Moreover, taking into account the causation principle, Your Honor, the causal link between Solid Dream's decision to launch without confirmed negative PCR test results and Ms. Arthurtia's losses is unequivocally direct and substantial. Had Solid Dream delayed the launch until receiving all PCR test results, Ms. Arthurtia would not have boarded while infected with COVID-19, nor would she have exposed other passengers. This failure is the substantial cause not only to the health deterioration among the passengers, but also directly led to the premature termination of the retreat, preventing Ms. Astortia from filming her planned yoga series. Counsel for the defendant may argue that the reason behind Soul Dream's decision to launch without the PCR test results is due to the closing launch window that they had. However, we submit that that is no excuse. Soul Dream chose to only perform the PCR test on the morning of the flight at 5 a.m. The lab suffered delays in releasing the results, and the flight was launched at 7 a.m. The time frame here expresses just how narrow the window for the results was. There was no reason why Soul Dream had to perform the test on the morning of the flight as opposed to perhaps the night before. After all, it is reasonably foreseeable that with such a narrow time frame, the test results may not be received on the anticipated time. The 2-hour time frame is negligence on Soul Dream's behalf, as they should have taken more care to anticipate delays from third parties or outside forces. Your Honor, Article 20 of the Law of Obligations concerns economic loss, which you may find on page 20 of the claimant's bundle. In applying it, Soul Dream's liability for her economic loss is evident. Soul Dream had a duty of care to ensure the safety and reliability on its services, which Ms. Astortia relied upon when planning to film her space yoga series, which is a significant economic activity expected to generate substantial revenue. This reliance was reasonable given Soul Dream's professional status and the promotional assurances of a safe and innovative space experience. And therefore, by launching prematurely without confirmed negative PCR results and inadequate safety protocols, Soul Dream has breached their duty, directly causing Ms. Astortia's economic loss, as she could not perform her planned professional activities, nor could she experience the service promised. Your Honor, this concludes my first submission. May I proceed with the second submission?
You can, and you've had about 16 and a half minutes, just so that you know.
Thank you. Your Honor, my second submission concerns Soul Dream's failure flight agreement. Your Honor, page 19 of the claimant's bundle presents Article 77 of the DIFC contract law, which defines non-performance as failing to fulfill any contractual obligations, including defective or late performance. Under the agreement, Soul Dream committed to ensuring a safe and successful flight. However, they failed to meet this obligation by deciding not to reschedule the flights despite the risks posed by the fast-spreading Vulcan variant. Safety should have been prioritized, particularly by waiting for PCR test results to confirm all passengers could safely participate. Furthermore, Your Honor, Clause 7 of the agreement highlights the importance of passenger health, requiring medical evaluations and histories to assess eligibility for the flight. Soul Dream neglected this duty by proceeding with the flight without confirming the negative PCR results, compromising passenger safety. Counsel for the defendant may argue Clause 4 of the agreement, titled Assumption of Risk, which states that the passenger acknowledges certain unavoidable risks, such as health risk and unforeseen events. However, we do not claim for the personal injury suffered, that is the contraction of COVID, but rather the losses that arose from my client's contraction of COVID. The risk of infection was foreseeable, as the virus had been circulating for months. and has a reputation for quick infection. Knowing this, the defendant should have taken more care as to tests for COVID more proactively, perhaps upon arrival 2 weeks before the flight, rather than on the morning of the launch. This oversight led to the mission being cut short and the passengers suffering from illness, ultimately failing to deliver the promised spaceflight experience. Additionally, Your Honor, Article 59 of the contract law, present in page 19 of the claimant's bundle, explicitly states that a party must achieve specific results when so obligated and exerts best efforts as would a reasonable person under similar circumstances. Soul Dream's decision to launch without definitive PCR results fell far below the standard of care expected in the space travel industry, as established previously. This breach directly led to the mission being cut short and deprived Ms. Asotia, and indeed all passengers, of the full yoga experience they were promised and entitled to under the contract. Once the flight was underway, it was discovered that my client was infected with the virus. The measures taken by Soul Dream were insufficient and ineffective, as evidenced by the rapid spread of the virus among all on board. This failure exacerbated the situation, leading to severe health risks and the inability of Ms. Asotia to carry out her professional activities, which were planned specifically around the unique environment promised by this flight. Your Honor, Article 80 of contract law, which is present in page 19 of the bundle, supports that even if a non-performing party attempts to cure their failure, the aggrieved party retains the right to claim damages for any harm caused by the delay and by the inadequacy of the cure itself. The measures taken by Soul Dream post-infection were too little and too late, and did not prevent the spread of the virus, nor did they salvage the mission's intended purpose. Your Honor, under Article 86 of the DIFC contract law, page 19 of the bundle, Ms. Asotia has the right to terminate the contract due to the fundamental non-performance. Soul Dream's actions not only substantially deprived her of what she was entitled to.
Just to let you know, you've had 21 minutes.
Thank you. Of what she was entitled to under the contract, but also she was demonstrated a disregard for contractual obligations central to the mission's essence. The sole purpose of the agreement was the space yoga experience, and my client was unable to participate in it due to Soul Dream's oversight and negligence. Without this purpose, my client would appear to have paid exorbitant amounts to be quarantined, which is undoubtedly unfair. Their failure gives substantial reason to believe that future reliance on Soul Dream's performance is untenable. The defendants may seek to rely on clause 4.5 of the agreement, which limits liability for negligence to $1 million. However, counsel for the claimant submits that such reliance would be unlawful. As it stands, my client received no consideration for her payment of $7.5 million as Soul Dream was unable to provide her the space yoga experience she was promised. Consideration is one of the pillars of a contract, and without it, a proper transaction
Not in the DIFC, it's not. There's no consideration in the DIFC, or at least it's not required for a binding contract.
All right, Your Honor. Since my client must be entitled to receive the full return of the monetary sum that she has paid. Therefore, we ask that Your Honors declare this clause impermissible. Your Honor, based on the evidence and the application of the law, it is clear that Soul Dream has both tortiously and contractually failed in its duties, directly leading to substantial damages to the claimant. We seek the court's favorable decision to find Soul Dream liable under both tort and contract, and request damages in the amount of $15 million for refunds and compensatory damages for the losses incurred. And unless I may assist you further, Your Honor, this concludes my submissions.
Thank you very much.
Okay, Judge Matthew, let me ask her a question that's raised in my opinion right now.
Yes.
According to the agreement, which I'm just screening right now on my desk, and clause number 5, medical evaluation.
Yes.
Okay, I think the claimant or your client, she should has done the declaration for her medical status, which she has a headache. And why she didn't mention this
Yes.
in the declaration? However, the
You're
headache,
yes.
just give me time to just continue my opinion, my ID. However, a headache is one of the symptoms of a COVID, as we all know. And she had this disease from a long time. She's suffering from this. Why she hide this? Why she didn't declare about this?
Your Honor, the reason as to why my client did not reveal her headache is due to private information, which will be discussed by my junior claimant, and that is an argument that will be made by the junior claimant for the junior counsel for the claimants.
Okay.
Yes, thank you.
Thank you.
Could
In which
you-
case, we will now hear from Senior Counsel for the
I have
Defendant.
one question for Kauthar, and this is about the limitation of liability clause, if you can speak about it more.
I'm sorry, could you repeat that?
So the limitation of liability clause, could you please explain why don't you believe the liability is limited to $1 million US?
We believe that the liability should not be limited, as Miss Artemis, our client, did not even participate in the experience promised, and that is due to their negligence and due to their inadequate safety protocols.
So you believe the clause is invalid, or what's
Yes.
your legal argument for this limitation of liability clause in the agreement signed by your client?
I'm sorry, I could not hear you very well, Ms.
I said, what's your argument for not enforcing this clause in the agreement signed by your client?
Your Honor, clause 4.5 of the agreement would only be sensible whether my client was able to fully experience the space yoga retreats. However, she suffered suffered an injury or loss in its duration, but that is not the present case. She did not suffer an injury, and she did not suffer a loss in this case.
Thank you.
Thank you.
Thank you. In which case, I'll invite Senior Counsel for the Defendant to make their case.
Thank you. Good afternoon, honorable judges and respectable audience. My name is Ophelia Ahmadzada, and I am a senior counsel representing defendant Solar Dream Inc., along with my co-counsel, Ms. Humarga Samzada, junior counsel. We are representing Solar Dream Inc. against Ms. Artemis Astrutea, and we shall address the two grounds for the claim and counterclaim respectively. And I will begin with the first ground regarding the defense to the claim that the defendant denies any liability to the claimant since it has acted to its best efforts to comply with safety measures, and there is no liability for the defendant under the tort as well. And my co-counsel shall address the second ground regarding the counterclaim of the defendant, that the claimant's breach of contract resulted in the loss of the profit for the defendant. We shall be pleased to the court to allocate 17 minutes as our speech time and 5 minutes each for rebuttal. Your Honors, at the heart of this case lies fundamental issue of fairness, where the failure of the claimant to disclose crucial medical conditions directly resulted in the breach of contractual obligations. And it's imperative to recognize that upholding contractual agreements is paramount, and that defendants should not be held liable for any economic repercussions stemming from the claimant's lack of disclosure. I will briefly state the main facts of the case. It's about the spaceflight travel retreat offered by the Solar Dream Inc., where the participants will be taken to a bespoke space station and offered the yoga and meditation classes. And this whole experience would have costed the 10 millions for the parties. While Miss Artemis Astrotea is the YouTuber with the 27.3 million subscribers, and she has suffered from chronic headaches, however, she has never mentioned it to the defendant. When the parties have signed the spaceflight agreement, under it, there were certain provisions requiring certain medical evaluations. Also, one of them required the filling out the declaration form and medical history log. However, the claimant has never met any mentioning of any of her diseases or symptoms. And on the date of the COVID 19 outbreak, the mandatory flow test and PCR tests were given to the parties. However, due to the non disclosure of the medical conditions of the claimant, the defendant could not properly identify her conditions. And with this fact in mind, the counsel would like to begin its arguments on the first ground referred to this court regarding the non breach of the contract by the defendant. And to address that, we will make two submissions. That the firstly, the crucial medical conditions were not disclosed by the claimant, and second, that the defendant undertook its best efforts, although some risks still remain unavoidable. And secondly, I will proceed to my second submission regarding the tort that defendant doesn't have any liability on and has not committed tort under applicable law. Your Honors, proceeding with our first argument, clauses 5.2, 5.3, and 5.5 of the agreement provide that the parties are responsible to disclose any changes in their medical conditions, and passengers are presumed to be unaware of any medical conditions to the best of their knowledge and the belief. And we clearly can see also, based on the governing law, Article 78 of the DIFC law number 6 of 2004, contract law, that the party may not rely on the non-performance of the other party if it was caused by the first party's act. Since the claimant has not disclosed her medical conditions, the defendant does not have to be held liable for not being able to determine the virus, the COVID-19 virus, within the claimant.
Is that right? Is the claimant's failure to disclose her headaches the cause of the defendant's failure to wait for the PCR tests? I mean, that was presumably a decision that it took irrespective.
Thank you for your question, Your Honor, which leads me to my next point, that surely it did not allow defendant to determine the COVID-19 virus, since there is close relationship between the constant chronic headaches of the claimant with the emergence of this virus. As we can see as well from the paragraph 9 of the case bundle, that during the quarantine of the passengers for the 2 weeks, the Miss Artemis started to suffer from severe headaches, which could have led to the outbreak of the virus. Also, she has not disclosed this information to the defendant deliberately, despite understanding the seriousness of her conditions. She was simply worried that she would not be allowed to the board on the flight, and therefore she has not disclosed this information. As moving to my next point, based also on the decision of Harley versus Haiti of 2017, it's a decision of the DIFC Court Small Claims Tribunal, where the first party cannot allege the non-performance from the other party when it failed to perform its own obligations and responsibilities. And as it can also be seen from the facts of that case, since the defendant in that case could not provide the correct signature, this had resulted in the delay for the claimant. As it can be seen from the non-performance of one party's act, then another party cannot be held liable. As in our case as well, the defendant would have known, if would have known about the chronic headaches of the claimant, he wouldn't have allowed the claimant to the board on the flight in the first place. Therefore, defendants should not be held liable for the actions of the claimant based both on governing law and case law. Your Honors, proceeding with our second argument, we submit that defendant also undertook the best efforts to comply with all safety requirements. As also stated in the clause 4.1 of the agreement between the parties, it states that the passenger acknowledges and accepts that the space travel involves inherent risks, uncertainties, and the possibility of unforeseen events. And the passenger is aware that despite the best efforts of the spaceflight operator, certain risks still may remain unavoidable. And to define best efforts and the duty of the best efforts, we refer to Article 59.2 of the DIFC Law Number 6 of 2004, Contract Law, which states that the party should make efforts as a reasonable person of the same kind in the similar circumstances would make. In our case, it is reasonable to say that defendant has made all the necessary actions when determining that the PCR test came out to be positive. He has asked all the passengers to wear masks and gloves for the duration of the whole retreat, and the meditation and yoga sessions went ahead without Artemis, and the space yoga mat became the sealed off the rest of the floating heaven. So he tried to make all necessary actions to prevent the transmission of the virus. Also, Your Honors, since the decisions from the leading common law countries are regularly cited as persuasive authority, we present also one of the cases, US cases, Osborne versus Montgomery. In this case, the standard of reasonable person was described as, and I quote, the level of care implemented under the same or similar circumstances by the great mass of mankind, often referred to as generally accepted standard. So the level of care presented by the defendant was reasonable to prevent the transmission of the virus. Your Honors, in light of this, for the first ground, we submit that defendant completed all of its best efforts as a reasonable person of the same kind would make. And with regard to that, we also submit that defendant is not liable for any damages alleged by claimant under tort as well. Even if the claimant submits that there is a duty of care due to which the defendant should be held responsible, we submit that there is no duty of care because, firstly, for a duty of care to arise based on the DIFC Law Number 5 of 2005, Article 32, there should be intentional breach of that obligation, and the claimant should suffer a loss as a result. First of all, we would like to submit a UK case as well, BPP Solicitors and Others versus Huggins Holland. In this case, a breach of duty for the claimant to prove that there is a breach of duty of care by the defendant, he should also prove that this duty was owed to him and it was a duty in respect of which the loss was suffered by the claimant. We can clearly see that defendant cannot be held liable for loss of earnings that the claimant incurred due to not being able to film yoga sessions, since, first of all, defendant was not informed that the claimant will film such kind of sessions on the YouTube. It is not provided in the agreement that it was an intention for the claimant to film such kind of yoga sessions. And it's not the duty of the defendant in this respect. So the loss cannot be connected to that. There is no causation link between it. Also, we cannot state that there is a liability of the defendant because he did not intentionally try to terminate the flight and the claimant suffered a loss as a result, the defendant has done all of the action for preventing the spread of the virus, but he could not expect that such kind of breach may result in loss of earnings for the claimant. And lastly, in terms of the tort, we also present that in the clause 4.5 of the agreement, which presents a limitation and exclusion clause, it is stated that, subject to applicable law, the space flight operator should not be held liable for any loss, damage, injury, or expense of any kind of arising out of or in connection with the space flight, except for liability arising from gross negligence or willful misconduct. In any case, the loss cannot be held to be above 1 million. Therefore, the claimant cannot demand or allege a loss of earnings in the amount of 5 million. If, Your Honors, you don't have the further questions, I would like to submit my arguments.
Thank you very much. There are no further questions from me, but my fellow judges may have some questions.
Yes, Ophelia, thank you. Could you please explain the reasonably duty of your client to wait or not to wait for the PCR test results?
Sure. So, as we were stated before, in the case of the common law countries, US case, the reasonable person standard is a level of care which a reasonable person would implement under the same or similar circumstances. So, in our case, when defendant learned that the PCR test came out positive for the claimant, he has asked all of the passengers to be isolated. And
I'm sorry. My question is before the takeoff. Why did you take off despite not receiving the PCR results?
So the defendant has relied on the advice of the nurse that the mandatory flow test was enough and there is no need for waiting for the PCR test. Also, there is numerous cases which present that the accuracy of the PCR test is not that high, so there is no necessity for waiting for the release of this test. And if defendant would have known the conditions, medical conditions of the claimant, he would have waited and not allowed the claimant to board on the flight. But since he was not aware of it, he decided to rely on the advice of the nurse and took all the necessary efforts to determine the virus.
Thank you.
Thank you. I don't have any questions right now.
Thank you very much. In which case, I will invite senior counsel for the claimant to present their rebuttals.
Thank you, Your Honor. Your Honor, I would like to first rebut the assertion that the defendant took reasonable measures to mitigate the risk. The assertion overlooks the critical fact that Solar Dream proceeded with the flight despite not having received all PCR test results. This decision contravenes the spaceflight agreement's stipulation that the flight may be rescheduled to ensure safety. The emergence of the Vulcan variant and its rapid spread characteristics necessitated a higher degree of caution, which Soul Dream failed to observe by relying on lateral flow tests alone, rather than seeking confirmation by a second test. This action directly contradicts the assertion of having taken the reasonable measures and constitutes a clear breach of duty by failing to ensure the safety of all passengers under heightened risk conditions. Furthermore, the reasonable measures cannot be said to have been taken. And why did the defendant not take care to consistently test for the virus? And why was the test only done on the morning of the launch? That simple action is grossly negligent at that point, and it would be too late for any preventative actions to be taken. As they had done the medical examinations prior, they could have carried out PCR tests with ample time to get the results prior to the launch. Furthermore, as to the argument regarding my client's headaches being a common symptom, we submit that because it is a common symptom, she may have connected it to some other issue, such as tiredness from travel or the fact that she has chronic headaches, which I would like to stress are untreated and undiagnosed. Furthermore, the headache she got was unpleasant, not debilitating as described by the virus symptoms. And so she couldn't have connected it to the headache that she was having at that time. Additionally, in regard to the assertion that Soul Dream
Yes,
did not...
can I ask you something here?
Yes,
During the declaration for her medical
yes,
health,
yes.
okay, do you think it was, or she has to do it, that she declared that she has a headache in the declaration, the medical checkup?
Yes, Your Honor, I believe that declaring the fact that she has a headache depends on her private. It is private information for her, and the once again it is the junior claimant's argument.
Okay.
What I am arguing here is the fact that her headache was unpleasant and not severely present as the virus symptoms. In regards to the assertion that Solo Dream did not breach the contract, Your Honor, we submit that this overlooks whether these measures were effectively and timely executed during the COVID-19 variant outbreak. The contract required adaptation to heightened risks, allowing for flight rescheduling to ensure safety. Soul Dream was aware of the variant's rapid spread and lacked complete PCR results. Nonetheless, proceeded with the flight, and this decision violated the contract's specific stipulation for rescheduling under known significant risks. Additionally, the defense's emphasis on initial medical evaluations and quarantine measures fails to account for their ineffectiveness, as the flight proceeded without conclusive PCR test results, directly breaching contractual safety requirements. And even if the trip's cancellation wasn't intentional, it was still an action done by the defendant, which caused my client loss. They must thus be held liable. And Your Honor, this concludes my rebuttals. Thank you very much.
Okay.
Thank you.
Yeah.
And then any rebuttal from senior counsel for the defendant?
Thank you very much, Your Honor, for the opportunity to rebut on the opposing counsel's statement. I would like to begin by stating that the claimant has not disclosed his medical conditions which resulted in the non-performance of the flight by the defendant. Addressing the points made by the opposing counsels, that firstly, the claimant itself has not performed and complied with contractual obligations by not disclosing any medical information about her chronic headaches. And there is no obligation under the defendant's side to wait for the PCR test result, as was stated by the opposing counsel. The second point mentioned by the opposing counsel, that the headaches suffered were not that severe from the claimant's side, we state that, as was stated in the paragraphs 8 and 9 of the case bundle, the headaches suffered by the claimant were severe, specifically during the second week of the quarantine of the passengers after they have arrived for the spaceflight retreat. As was also discussed by the by the opposing counsel, she stated that there was no obligation to declare the severe headaches of the claimant in the declaration form or medical history log. However, the medical history log required listing all kinds of ailments that the person suffers from or have previously suffered from. And also the declaration form required listing all kind of medical conditions or symptoms that may have affected the person's fitness or participation in the travel retreat. So there is a clear provisions in both of the agreement and the declaration forms listing the obligations of the claimant to disclose medical conditions. And there was no kind of obligations under the defendant's side to wait for the PCR test. Therefore, we submit and conclude that defendants should not be held liable for the breach of contract, and instead it was the claimant who has not performed her contractual obligations which led to the non-performance from the defendant's side. Thank you.
Thank you. I'll just check whether there are any final questions from any of the judges.
Yes, Judge Matthew. Once back to clause number 7, space flight operate safety protocols. It says the space flight operate shall ensure compliance with the safety requirements and their applicable law. I will not go for the further, for all the paragraph details, but considering now we are during COVID time, or we are under the impression that there is COVID still existing, and the PCR is very important test for this for the safety of the passenger. How you just can say back to Judge Muhammad when he said why they didn't wait for the PCR, considering now the environment is not safety, COVID is there or existing, PCR is one very important test, and your client, they didn't wait for the PCR result. They took the flight and they take off. So how can you define this? This is according to clause number 7, the protocol of the safety or safety protocols.
Thank you very much for your question. I understand your concern, Your Honor. However, we have to understand as well that the claimant's non-disclosure of her chronic headaches as well affected the not ability of the defendant to determine virus within herself. Also, the safety protocols, of course, we understand the safety protocols mentioned in the agreement. However, there is no explicit mentioning that we should wait for the release of the PCR tests, and also considering that the defendant took all other necessary measures, such as quarantine, isolation of the claimant from other passengers. He took all necessary measures under the safety protocols and try to make all its best efforts to comply with them. However, we have to understand that there are certain risks that still remain unavoidable, and in our case, they were unavoidable due to claimant's non-disclosure of her chronic headaches. Thank you.
Thank you. In which case, I now invite junior counsel for the defendant to open the case in respect of the counterclaim.
Thank you very much. Good afternoon, honorable judges and respective audience. My name is Kumar Gasimzadeh, and I'm a junior defendant in this case, and I will submit the counterclaim on behalf of the Solar Dream Inc., which is a defendant. In today's pleading, I will present the counterclaim. I will start by arguing that the claimant is liable for breach of contract since she failed to declare about her medical condition. I will then continue by arguing that the claimant's action caused the reputational loss for the Solar Dream Inc., which is in an amount of $5 million. To begin with the facts of the case shortly, I would like to submit that the defendant and claimant concluded a space flight agreement on 13 December 2023. And the defendant offering space flights and travel retreats conducted a week-long series of space mediation with yoga classes. Pursuant to the space flight agreement, there is a requirement for the passengers to disclose information about their medical conditions. And Artemis didn't disclose about her medical condition when signing the agreement and also afterward. And Artemis angrily described the full sequence of the events after the travel retreat, which is a breach of the agreement, First of all, for failing to declare her medical condition and also resulted in a reputational loss for the Solid Dream
What
INC.
specific words of what clause do you rely on for the contractual obligation to disclose the headaches?
We refer to the Article 5, Clause 5 of the Spaceflight Agreement, which shows the
Well,
medical.
that has 5 subclauses,
Yes,
6 subclauses.
5.2.
5.2, which words?
It says that the passenger declares and represents that, to the best of their knowledge and belief, they are not aware of any medical conditions or symptoms of a potential medical condition that may affect their fitness to participate in the space flight. Even though there is no list of the illnesses, diseases, and also there is no mention of headache in the provision of the space flight agreement, it is not reasonable to expect from the Solid Dream INC, the defendant, to include all the list of diseases in the space flight agreement. Therefore, we consider and we submit that the claimant have obligation under the Spaceflight Agreement Clause 5 to disclose information about her medical condition. And for the counterclaim, the defendant will make 2 submissions. Firstly, the claimant breached the contractual obligations by not disclosing information about her medical conditions, and secondly, Artemis' publicly disclosure of information about retreat leads to the reputational loss for the Solid Dream INC. Your Honor, firstly, we submitted that claimant is responsible for the breach of contract by not declaring information about her chronic headaches. As a matter of first argument, we concluded that in the spaceflight agreement, the obligations of both parties are determined. I would like to refer to Article 58 of the DIFC Law number 6 of 2004 of the Contract Law, which is the governing law to the spaceflight agreement, which provides that, and I quote, each party is bound to cooperate with the other party when such cooperation may reasonably be expected for the performance of that party's obligation. In that regard, the duty to cooperate is considered is one of the lex mercatoria principle, as it's essential for the smooth commercial dealings. And lex mercatoria is a set of rules for solving a dispute and act as a principle, and its main purpose is to enable the another party to perform its obligation and thus earn the counter performance. This is also based upon Article 5.1.3 of UNDRA Principles of International Commercial Contracts. The commentary of that article makes clear that there are many instances which the parties are expected to cooperate with each other, and this cooperation also includes the disclosing of information which is important for the performance of the contract that were concluded between the parties. And this cooperation may be required at the time of formation of the contract and also the performance of the contract. And also I would like to refer to Article 77 of DIFC Law number 6 of 2004 of Contract Law, which says about the non-performance of the contract and shows that non-performance is a failure by the one party to perform any one or more of its obligation under the contract. And as I stated before, in Clause 5.2, 5.3, and 5.5 of the Spaceflight Agreement explicitly shows that the passengers should declare their medical condition and promptly report any changes and acknowledge their duty in doing so, highlighting their obligation to preserve up-to-date information related to the fitness for the travel retreat. And for that, I would like to refer to court problem, the Moot court problem, page 5, paragraph 8, which shows that Mrs. Artemis was aware of her chronic headaches, and she decided not to declare about her chronic headaches to the Solid Dream because she was afraid that these particular circumstances can affect her participation in the travel retreat. And we saw that This is purposefully made by the Mrs. Artemis that she didn't disclose her medical condition to the Solar Dream Inc., which resulted in a breach of the contract. In that case, also I would like to refer to Article 3.4.1 of United States Federal Aviation Administration Recommended Practices for Human Spaceflight Occupant Safety Protocols, which is the main part of the spaceflight agreement according to the Clause 7, which provides that the medical consideration is one of the key factors in spaceflight operations, so that flight crew members shouldn't fly if they have a medical condition or psychological change that can affect their performance and can affect their life and can create a danger for their life. Also, if we consider that the main reason for claimant to participate in this retreat is to heal and cure her chronic headaches, the Mrs. Artemis should declare about her chronic headache to the Solar Dream Inc. when she's signing the agreement. And we also saw that Mrs. Artemis signed and also read the copy of spaceflight agreement before the signing it, and she was aware of the fact that she had an obligation to declare her medical condition. And we know from the facts of the case that despite the claimant's commitment to the healthy lifestyle, she has experienced the headaches for the past 5 years. Even after consulting various doctors and exploring numerous alternative treatments, she has been unable to prevent recurring the headaches. Nevertheless, claimant had no mention of her chronic headaches because she was afraid of that the defendant would not allow her to participate in the retreat. Consequently, as a conclusion of my first argument, we submitted that the claimant breached her contractual obligation by neglecting to inform defendant about her chronic headaches, which has also resulted the defendant would not allow her to participate in the travel retreat. And for the second argument, we submit.
Before you move to the second argument, you are building your argument on the intention of the claimant. How did you reach this conclusion about her intention hiding this information?
Thank you very much for your question. Firstly, I refer to the Article 5 of the Spaceflight Agreement, which requires the declaration of the medical condition. And I refer to the fact that firstly, Artemis was aware of her medical condition related to the chronic headaches. And also, the intention of the Mrs. Artemis to participate in the travel retreat is to cure her chronic headaches. And therefore, she also should inform about the situation to the defendant side.
Thank you.
And for the second argument, we submitted that the claimant is liable for the damage, for the reputational loss that occurred to the Solar Dream Inc. in an amount of $5 million. I refer to the Article 109 of DIFC Law Number 6 of 2004 of Contract Law, which stipulates that a non-performance gives the aggrieved party a right to damage, either exclusively or in conjunction with other remedies, except where the non-performance is excused under this law. As a specific form of the damages, as defined in Article 110 of the DIFC Law Number 6 of 2004, where it is stated that the aggrieved party is entitled to full compensation for harm sustained as a result of the non-performance. Such harm includes both any loss which it suffered, any gain of which it was deprived, taking into account any gain to the aggrieved party resulting from its avoidance of cost and harm. And also, I would like to refer to the case of Jayman Holdings versus International Financial Center Authority and Dubai International Financial Center Investment 2022, which is the first instance case of the DIFC court. It's not binding for this court, but for the persuasive purposes, I would like to refer to this case. And in this case, the court concluded that, and I quote, "It's now accepted that the reliance loss claimed is an alternative to the expectation loss, The latter is to be assessed on the basis of what would have occurred if the defendant had performed as it alleged they should have done. It shows that there must be a direct link between the actions of the party and the loss occurred. And we concluded that the Artemis angular description of the sequence of the event after the travel retreat in her YouTube channel, which has millions of subscribers, including her pre-departure headaches, which she had aware before the flight, which her chronic headaches was not a result of the travel retreat, resulted in a significant reputational loss for the Solar Dream Inc. And defendant, after the relief of this YouTube video, there are lots of passengers that cancel their tickets and for the future retreats, and it resulted a reputational loss for the Solar Dream Inc. Therefore, we submitted that claimant's actions have adversely affected the defendant's reputation and deprived it also future earnings. Therefore, defendant should be awarded $5 million lost profit, which is a reputational loss for a Solar Dream. Because as a conclusion of my two arguments, I would like to submit that, firstly, if Mrs. Artemis didn't breach the contract and declare her chronic headaches a medical condition to the Solar Dream Inc., the Solar Dream would not let her to participate in a travel retreat. And also, the disclosure of the information about the sequence and consequences of the travel retreat in a cancellation of the tickets for the future retreats, which has resulted for the reputational loss for the Solar Dream Inc. Your Honors, we respectfully request the court to declare that the claimant is liable for the breach of contract and should pay as a reputational loss for the Solar Dream Inc. in an amount of $5 million. Thank you.
Thank you. I'll just check whether there are any questions from my fellow judges.
Nothing from my side, Matthew.
Thank you. In which case, I will invite junior counsel for the claimant to open the claimant's case on the counterclaim.
Thank you, Your Honor. May it please the court, my name is Kabisha Shilin, and I am the junior counsel representing the claimant, Ms. Artemis Astrathea, in this case. Your Honor, we submit that the key issue in this claim is whether Ms. Astrathea is liable to Solar Dream Incorporated by way of breaching their contract. Your Honor, I will be addressing the defense to this counterclaim, for which I shall be making two key submissions. Firstly, that my client cannot be found liable for breach of contract due to the unlawfulness of Clause 5.2 and 5.3 of the Spaceflight Agreement. Secondly, and subsequently, my client's performance was in no breach of contract signed by both parties, as she had the right to protect her sensitive medical privacy. Your Honor, may I proceed with the first submission?
You may.
Thank you, Your Honor. My first submission regards the nature of the Clause 5.2 and 5.3 of the Spaceflight Agreement. We submit that because those clauses are unlawful in nature, there cannot be a breach of them, and thus the defendant's claim that Ms. Astrathea failed to fulfill her obligation under those clauses cannot succeed. Clause 5.2 states that the passenger declares and represents that, to the best of their knowledge and belief, they are not aware of any medical conditions or symptoms of a potential medical condition that may affect their fitness to participate in the spaceflight. This clause was enforced by the declaration form, which my client was asked to fill, and the medical log, which asked that she list all conditions she had or is suffering from. The claimant did not disclose the condition of her chronic headaches, and the defendant claims that that non-disclosure is a breach of contract. Your Honor, counsel for the claimant does not dispute the fact that there had been non-disclosure and that by the plain wording of the contract, Ms. Astrathea failed to meet her obligations. However, counsel for the claimant submits that this obligation to disclose any and all medical information is an unfair contractual term as it constitutes a breach of Ms. Astrathia's personal privacy, and thus it is unlawful. Your Honor, allow me to guide you to page 22 of the court bundle, to Law Number 5 of 2023, establishing the Dubai Corporation for Consumer Protection and Fair Trade, which may be applied here. Under Article 2 of this law...
May it be applied here? Does this apply in the DIFC, or is this a law that applies in non-DIFC Dubai?
It is a law that applies in the DIFC court. Yes, Your Honor.
Looks to me like a federal law, and UAE federal laws don't necessarily apply in the DIFC. So I would need some persuasion that Law Number 5 of 2023 applies at all in the DIFC. But let us assume, for the sake of argument, that it does apply, and you carry on with your submissions.
For the sake of persuasion, then I shall continue. Thank you, Your Honor. Under Article 2 of this law, also found on page 22 of the court bundle, Ms. Astrathia is considered a consumer, as Ms. Astrathia is a legal person who has obtained a commodity or service by entering a contract in relation to the commodity or service being provided. In this case, Ms. Astrathia had obtained the service provided by Solar Dream, the space yoga mat, through a contract entered by both parties. The service in question is the yoga mat retreat experience. This contract required the passenger, Ms. Astrathia, to disclose her medical history to Solar Dream so that Solar Dream could ensure the safety of its passengers for the duration of the space yoga mat experience. As such, the spaceflight agreement falls under the jurisdiction of Law Number 5 of 2023. To expand upon this, Your Honor, if you could look at page 22 of the court bundle, Article 9 of the Law Number 5 of 2023 states that the law's function is to safeguard the security and confidentiality of consumers' personal data and prohibits its unauthorized use for commercial or promotional purposes without obtaining prior consents from the consumers. The duty of confidentiality here is governed by Article 29 of the DIFC Law Number 6 of 2004, titled Law of Contract, which could be found in page 18 of the court bundle. The article states that where information is expressly given as confidential by one party in the course of negotiations, the other party is under a duty not to disclose that information or not to use it improperly for its own purposes, whether or not a contract is subsequently concluded. Currently, as it stands, counsel for the defendant claims that it is due to Ms. Astrathia not disclosing her information, they suffered a loss. But Your Honor, my client's medical history is being used to justify Solar Dream's failure to provide the passenger with a safe and successful mission. This contradicts
a breach of Article 2. So I have a real problem understanding the relevance of Law Number 5 of 2023 for two reasons. Firstly, Article 9 appears to impose a duty on a public body, the DCCPFT, not on private parties. It requires them to do things like raise awareness.
Right.
And secondly, are you really suggesting that the law doesn't permit people to disclose their medical information to other people? Because obviously that happens all the time. People need to know, and a space flight is a perfectly good example. People need to know bits of medical information. The point is that it obviously has to be kept confidential. But are you asserting that Article, I think you said it was 29 of the contract law, prevents the defendant from even raising this point in legal proceedings?
Your Honor, I will be elaborating more on it.
Information. So I don't
Yes,
understand.
I will be. I will be elaborating further on how her medical information is private, and she has a right that gives her a right to protect it. My first submission is regarding how unlawful the clause is.
You didn't give it, isn't it? Surely
Yes.
the point that the defendant is making is not that we're not talking about someone having medical information and misusing it. the defendant's point is that your client didn't provide the medical information. That seems to me to be different.
Right. Which is why we are arguing that that clause itself is unlawful, because it stands to allow the defendant to have an economic gain because of this medical information by providing a safe service.
So you're saying that a space flight operator can't ask a potential passenger any question about their health before they're allowed on board?
They can. No, Your Honor, they can. But this clause requires them to provide all their medical information, which is why we argue that all is unfair, because she has a right to at least have some privacy for certain of her medical conditions.
But presumably a medical professional who has to assess whether someone is fit and healthy to undertake a space flight needs access to all the medical information.
She has indeed given certain medical details about her other conditions, like anything else, blood tests, urine tests, everything else, except for this headache is the only condition that she chose not to disclose.
Yeah, well, I understand that, but why does she, as somebody who is not a doctor or medically qualified in any way, get to decide which bits of information are relevant to the medic?
I will be discussing that in my second submission.
Okay.
But briefly, it is due to the sensitivity. Yes. May I continue, Your Honor?
Please.
Yes. This contradicts Article 29, as Solar Dream had intended to use passenger medical history as a method of determining which passengers are fit to travel, and would thus provide the most successful results for the space Yogamet experience, meaning that passengers with poor medical histories would be excluded from the experience, while passengers with healthier medical histories would be more qualified to participate in the experience. Your Honor, we would like to emphasize that this strategy of employing medical data may at first glance be seen as a method to ensure all passengers' safety and conveniently meet the national and international regulations and safety protocols. However, Solar Dream stands to make an economic gain from the collection of the passengers' medical information. This is simply because the selection of passengers for their sensitive medical information is done with the aims of providing a more successful spaceflight. As a result, the more successful the flight, the more Solar Dream's reputation grows, and other individuals are encouraged to participate in similar experiences provided by the defendant. This may breach the principle of confidentiality in Article 29 of the DIFC contract law, as medical information is confidential information, and it was thus improperly used for personal purposes. Counsel for the defense.
I come back to my point that Article 29 is dealing with information that goes from A to B and about B using that information improperly. But the problem here is about information that wasn't communicated. So it's not about the defendant misusing some information that your client had given. It's about the fact that your client hadn't given the information. So I'm still not your argument.
So what we're trying to establish is that the clause itself is unfair and unlawful because of this, because they request to disclose all medical information. Then for the second submission only, I will be arguing how she has a right to protect that information, specifically her headache.
Okay.
May I proceed, Your Honor?
Yes.
Counsel, thank you, Your Honor. Counsel for the defendant may argue that Ms. Astruthia has voluntarily signed the agreement and disclose all her medical information, and thus the use of her information cannot be improper or unconsented. However, Article 29 of the DIFC contract law, found in page 18 of the court bundle, states that the duty to protect confidentiality stands whether or not the contract was signed. As such, the term may be found to be unlawful even if it has been signed and agreed upon. We submit that our contention is not with the publication of the information, but rather its usage by the Solar Dream. As previously discussed, the availability of every piece of information that regards every aspect of a person's medical history, as demanded by the agreement, grants SolarDream the ability to take advantage of it and create economic gain, and private information must not be used by companies for such aims as per Article 29 of Law Number 6 of 2004. This concludes my first submission. Your Honor, may I proceed with my second submission?
Yes.
Thank you, Your Honor. My second submission is that Ms. Astrathia was entitled to non-disclosure of her medical conditions as she has the right to protect her private medical history. In order to establish this, the information concerned must be private in nature. I would like to draw inference from the common law case of the United Kingdom. Your Honor, allow me to guide you to page 15 of the court bundle to the case of Campbell and Mirror Group newspapers, decided in 2004 and reported in the second volume of the Weekly Law Reports on page 1232. Your Honor, would you benefit from the facts of this case?
No.
Then I shall proceed, Your Honor.
This is all about the Human Rights Act, isn't it, and the European Convention for Human Rights?
Yes, yes.
Those treaties don't have any application.
However, I did not use that. I just used the legal proceeding of this case, just the legal principle.
But this case is based on interpreting those provisions, isn't it?
Which is why we'll use as a persuasive for my arguments.
Okay.
Thank you, Anne. Shall I proceed?
Yes.
Thank you. Here the court held that there had been a breach of confidentiality since the published information was of sensitive and private nature. Your Honor, if you could look at page 16 of the court bundle, paragraph 2, line 5, commencing with offensive that since. The court summarizes that details related to the condition of the claimant's physical and mental health and their treatments were akin to the private and confidential information contained in the medical records. If the court were to take this case into consideration, Ms. Astrathia's medical records may be considered private and confidential in nature, and persons are entitled to protect their private information. Your Honor, to support this, I would like to bring a significant case from the United Kingdom common law to your attention. It is the case of Douglas and Hello Limited, decided in 2003 and reported in the first volume of Entertainment and Media Law Reports, page 28. You may find this case in page 10 of the court bundle. Does Your Honor require the facts of this case?
No.
Then I shall proceed, Your Honor. Counsel for the claimant brings this case before this court for its test for the reasonable expectation of privacy regarding private information. As already mentioned, medical history falls within the category of private information, and rightfully so, the claimant has a right to protect that information. The question is whether Ms. Astrathia has a reasonable expectation of privacy regarding her medical history, as per the case of Douglas and Hello. Regarding the current case, it can be argued that the claimant did in fact have a reasonable expectation of privacy regarding her medical history. Any individual placed in a similar situation may find that they do not feel comfortable providing such in-depth information about their medical histories because there is no way of knowing whether that information will be used for one or more, for more than just an insurance that excludes liability of SolarDream. As such, my client provided a lot of medical information, but she is entitled to refrain from disclosing some of it as she has the right to protect her private information. And in this instance,
why can't a space flight provider say, we offer space flights, we will only offer space flights to people who are fit and healthy. You have to come along and give disclosure about whether you're fit and healthy. And if you don't want to give that disclosure, then you don't sign up for the space flight. But if you want to go on the space flight, you have to give that disclosure. So she's entitled to protect her records if she wants, but that means not going on the space flight. It seems to me she's signed up to a process to undergo a medical. I mean, people undergo medicals all the time.
I would be discussing this point further. However, briefly, Your Honor, her medical condition was an undiagnosed condition. Her headaches, this condition that the defendants claim, was undiagnosed by many doctors. Therefore, if she wants to keep that information private, she would have the right to, but she did disclose all her other medical conditions as mentioned before. Anything else that is regarding her health, she did allow that. May I proceed, Your Honor?
Yes. Although your time is limited, you've now hit, as a team, 45 minutes. So
Yes, I shall conclude immediately.
brief.
Okay. In this circumstance, Ms. Astrothea would have the right to protect her information because there is no guarantee that her medical history would not be used for commercial gain, which is prohibited under Article 9 and Article 29 as mentioned before. Your Honor, to conclude this submission, Ms. Astrothea did not breach the contract with Solar Dream by way of non-disclosure of her full medical condition, as it is private information which she is entitled to protect and hide. In conclusion, Your Honor, the counsel for the claimant submits that the clauses for the agreement that demand that my client disclose all her medical information should be seen as unlawful as they misuse her private information. Secondly, the claimant has not breached the contract with the defendant by non-disclosing her medical condition as it is private and sensitive information, which she has the right to protect. Your Honor, unless there are no further questions, this concludes the case of the claimant.
Judge Matthew, can I ask something, please?
Yes.
What's the claimant?
Yes, Your
Back to the point of disclosure, according to the contract law, DIFC contract law number 6, 2004, and
Yes.
if you are referring to the clause 57, the implied obligations, and 58, the cooperation between the parties, how you can manage your argument?
Your Honor, could you repeat the question?
Okay, once again, about disclosure, about she didn't disclose some information because they said the privacy, whatever you say. And
yes.
The defendant and their skeleton agreement, ground number 3, they said the claimant's non-disclosure is a violation of contractual obligation. Okay,
yes.
Then you will go to the contract law of DIFC number 6, 2004, clause number 57 and clause number 58. 57 is said implied obligations, and 58, yes. I will not go to the details because there is no time. It said the cooperation between the parties. It only that she supposed or she has the obligation to disclose about her medical status or her medical or. So this is. Do you think it is forming a violation to the contract's obligations?
No, Your Honor, because we submit that she has a right to privacy. Therefore, she moreover, this condition has not been diagnosed, and we do believe that because it's been untreated for years, she did not consider it to be a very severe condition that she has to disclose as per the agreement. Moreover, as established before, she does have a right to this privacy due to the sensitivity of this information.
Just one more. I will not take more time. It says in 57, okay, the nature, okay, implied obligations arise from the nature and purpose of the contract. Let me just make it brief. There is a flight or space flight. There's a people with her, and this could affect the others. She didn't disclose. She's protect her privacy, but she's affecting the others and causing losses and damages. So how you can make the balance between the both items? The privacy.
Your Honor, she was not aware that she was having COVID-19 symptoms because
headache.
Yes, headaches. Yes, she did not know that she was having a COVID-19 common symptom because she has been having it for like more than 5 years, and again, it was undiagnosed by many doctors. So therefore, she thought that it was something to do with the jet lag or because of the travel that she was having.
It's okay here. I just say this is for me is enough. Thank you, Judge Matthew, for giving me the time.
No, thank you very much. In which case, I will now invite junior counsel for the defendant for your brief rebuttal.
Thank you very much, Your Honors, for the opportunity to rebut the opposing counsel's argument. The junior counsel from the claimant side stated that the obligation related to the disclosing of information about the medical condition, including in the spaceflight agreement, is unfair and unlawful, which is against the personal private data. As a defendant, we didn't deny the claimant's right to privacy. Nevertheless, I would like to refer to Article 3.4.1 of United States Federal Aviation Administration Recommended Practices for Human Spaceflight Occupant Safety Protocols, which shows that the medical consideration is one of the key factors in spaceflight operations, that the flight crew members and also the passengers should not fly if they have a medical condition or psychological disease that can affect their health during the spaceflight. And as we can see from these protocols, which is an integral part of the spaceflight agreement and also other international principles, the medical consideration is one of the important provisions that should be added in a spaceflight agreement. And it is reasonable and also important to add it to the spaceflight agreement by the defendant. And also the claimant referred to the word of all, which shows that all the medical conditions and history should be declared to the defendant, which is not also unfair, because Solar Dream Inc. has to know all the details related to the medical conditions and medical history of the passengers to provide the security in the travel retreat, in the spaceflight retreat. Secondly, if the claimant has a disagreement with the provision and clauses included in spaceflight agreement, she didn't mention her disagreement related to that clause, and as we can see from the facts of the case, the claimant, Mrs. Artemis Asteroitia, read and signed copy of the spaceflight agreement. Nevertheless, the claimant deliberately hid this information in her medical records and did not disclose and declare it to the Solar Dream Inc. And also the claimant disclosed that the claimant submitted that Solar Dream should act the medical condition as a private and confidential information. Nevertheless, it's clear from the facts of the case that Mrs. Artemis Asteroitia, after the spaceflight retreat, herself disclosed her pre-departure headaches in her YouTube channel in one of her videos. How the claimant can expect from the defendant to act as a private and confidential information to her headache, even though she disclosed information about her pre-departure headaches in her YouTube channel, which has millions of subscribers. And for the second argument made by the claimant has submitted that claimant has expectation to this information as a confidential information, but it's the requirement of Solar Dream Inc., which operated and conducted space flight, and the Solar Dream Inc. provides space flight if the passengers declare all their medical conditions to the spaceflight operator, which is a freedom of contract, and it's not unfair and unlawful and against the principles. As we consider that headache also one of the sign and also the factor can affect the fitness of the passengers, and the claimant is liable for the disclosure of such information to the Solar Dream Inc. Therefore, as a conclusion of rebuttal, we request the tribunal to consider the claimant is liable for the breach of contract. Thank you.
Thank you. Any questions from the judges?
Not from my side, thank you.
Thank you. And then I think finally we have rebuttal from the junior claimant. You are strictly out of time because you used more than 45 minutes, but in a minute, if there's anything you'd like to say that isn't just a repetition of what you said before, then do say it.
Yes, Your Honor. Thank you. I would firstly like to rebut the argument that the counsel for the defendant said that my client hid information intentionally due to the fear of being disqualified. However, my client did not disclose her chronic headaches due to the fear of adverse. She didn't disclose it because of the fear of adverse consequences, as she would be discriminated due to her mysterious illness that had been left undiagnosed, regardless of multiple visits she had to many doctors. This sufficiently proves that she would take offense if such information would have been disclosed, but thus determining it as private information that she has the right to protect. Moreover, the counsel for the defendant also mentioned that international space regulations require participants to provide medical information. However, we argue that it is simply because the selection of these passengers per their sensitive medical information is done with the aims of providing a more successful flight. Therefore, we conclude that this is an economic gain using such information. Moreover, lastly, the counsel for the defendant also said that she voluntarily signed the agreement to disclose all her medical information. However, we state that Article 29 of the DIFC Law number 6 of 2004 states that the duty to protect confidentiality stands whether or not a contract was signed. Therefore, it does not matter whether she signed the agreement on her own volition. Your Honor, this concludes the rebuttals from the counsel for the claimant.
Thank you very much, and thank you to all of you for participating. The judges are going to confer, and we will come up with a score and send that on to the people running the moot court, and you'll find out who progresses through to the next round. But you've all of you done very well. This is a very challenging problem, and there's lots of legal authorities that you might draw upon. I think you've probably been given feedback already in the sort of preliminary rounds. So given that we're already running over time, unless either of my judges has anything that they're burning to say by way of feedback.
Thank you, Judge Matthew. Nothing from my side.
Nothing from my side also, other than well done for everybody.
In which case, I think to keep things easy, I might ask everyone apart from the judges to log out of this room, and then the three of us can discuss the scores.
Thank you very much, Your Honor. Thank you.
Thank you very much, Your Honor.
Right. For my part, I thought the defendant was the better team. Particularly, I didn't like, as you probably detected, the argument from Middlesex about privacy, and I don't have to tell you about my medical history. I can keep it private. I just didn't think that worked at all. But I'm happy to sort of run through scores for individual